Right, that's you.
You. Well, good morning, everyone, and welcome to this virtual pre-examination meeting. The purpose of today's meeting is to discuss the procedural arrangements for the inquiry in relation to an application by Fetteresso Wind Limited, consent under Section 36 of the Electricity Act 1989, and a direction under Section 57(2) of the Town and Country Planning Scotland Act 1997. The application proposes the construction and operation of a wind farm comprising up to 10 turbines, 4 of a maximum height base to tip not exceeding 200 meters, 3 of a maximum height base to tip not exceeding 180 meters, and a further 3 of a maximum height base to tip not exceeding 149.9 meters. The wind farm would be located in the vicinity of Fetteresso Forest, approximately 15 kilometers west of the town of Stonehaven. My name is Andrew Sykes. I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, generally known as the DPA. And I have been appointed by the Scottish Ministers to consider the application and report my findings and recommendations to them. Now, before I go any further, there are a few things I'd like to say about today's meeting. Firstly, as you're probably all aware, the meeting is being broadcast live to the DPA website. The video record of the meeting will be retained on the website until ministers have taken a decision on this matter. In addition, by taking part in this virtual meeting, you are consenting to being filmed, to the use and storage of those images and sound recordings, and any information pertaining in them for webcasting and training purposes, for the purpose of keeping historical records, making those records available to the public. Secondly, while we're all becoming increasingly familiar with virtual meetings and proceedings, could I nonetheless ask you to keep your videos turned on throughout the meeting and to mute the sound when you're not involved in a discussion. You might also find it helpful to have your screens on gallery view. If you need to attract my attention, please just raise your hand or wave and I'll see that you wish to speak. Thirdly, and importantly, if you're part of a team participating in this meeting, there is more than one of you in a room, I would ask you to please ensure that you observe the safe physical distancing from your colleagues at all times. Suspend proceedings where participants fail to comply with this requirement. As I mentioned in the meeting invitation, it is possible for parties represented by more than one person to join the meeting on a separate line. Now, I don't envisage a need for a break during the meeting, but please just ask if anyone feels the need for a short break at a convenient moment. Now, the purpose of today's meeting is solely to discuss the administrative arrangements for the inquiry, prior disclosure of the cases that parties wish to lead. There will be no discussion concerning the merits or otherwise of the application or of parties' cases. You should all have received an agenda for today's meeting, which was issued a couple of weeks ago. You should also have received a proposed timeline for the submission of documents and statements, etc. I thought it would be helpful to attach to the agenda a series of notes on the points that we need to discuss this morning, including a provisional assessment of the main issues to be addressed at the inquiry. We'll discuss shortly. I hope that will give parties time to consider these matters and make for a more effective meeting. Finally, although the situation with the pandemic is improving, I do not rule out the need for a second pre-inquiry meeting at some point should the situation change, to review any arrangements that we agreed to today. Second pre-inquiry meeting will also allow the opportunity to check on progress with preparations for the inquiry. However, the position of the DPEA at present is that it will continue to hold virtual inquiries while physical distancing arrangements remain in place, given the associated difficulties of securing large and suitable venues. As I've noted, the situation may change before the inquiry takes place. The DPA has, I think just the end of last week, has issued updated guidance on this matter, available on our website. We'll include a link to that document in the notes of this meeting. So before we go any further, are there any questions on matters I've just outlined. Now, the second item on the agenda is to discuss those, or to identify those representing the principal parties and others in the inquiry. I'll start with Mr. Innes, as representing Fetteresso Wind Farm, and then I'll go on to the council, followed by the Community Council, before moving on to others that have indicated that they wish to participate in the inquiry. Mr. Innes.
Yes, good morning, sir. My name is Colin Innes, and I'm a partner in the law firm of Shepherd and Wedderburn, and represent the applicants at this pre-examination meeting. This morning, I'm accompanied by quite a number of people, and I just thought it would let you know who those are, just so that you know who's in the meeting. I've got Judy Aitken, who's a senior project manager, and Finlay Bex-Phelps, UK Development Director of Fred Olsen Renewables, the applicant's parent company. I've got Graham Kristelov, Senior Project Manager from Natural Power Consultants, Ewan Hutchinson, who's an Associate Director Consenting from Locogen, who's providing planning advice and will be the expert witness, and Brian Denny, who's a Senior Director at Pegasus, who will be the landscape and visual advice and expert witness. And finally, from my office, I have Scott McCallum and Kenna Bissett.
Thank you very much.
Thank you, sir.
Aberdeenshire Council.
Good morning, sir. I'm Ewan Brown. I am counsel appointed by Aberdeenshire Council for this case, and I'm accompanied this morning on this call by Arlene Gibbs, who's principal solicitor with the council, and by James Hewitt, who's the planning case officer for the application.
Thank you. Newside Community Council, is it Mr. Clapham?
Yes, good morning, everybody. My name is Russ Cleffin. I'm representing Fuchside Community Council, who are the successor to Fuchside West Community Council, just in case anybody is concerned about that. And so, indeed, I've been asked to represent the council for this meeting and any future meetings.
A number of individuals that have made representation on the inquiry and indicated that they wish to participate. I'll start with Mr. Cole. Is Mr. Cole?
Yes, my name is Brian Cole, local resident in one of the properties most affected by the proposal.
Mr. Curry. Kilford, I think I've seen your name on the screen.
Yeah, Bob Kilford, I'm a local resident. My property is also close to the proposed wind farm and faces directly towards it.
So, Mr. Burgoyne. Mr. Strachan. Anybody else that I've missed who's on the call that I screen? I would also add that Scotways, the Scottish Rights of Way and Access Society, was unable to attend the meeting today, but they do wish to make a further written submission effects of the proposed development on public rights of way. I want to discuss that shortly. Third item is just a comment about the Code of Practice for handling inquiries under the Electricity Act 1989. For those unfamiliar with this process, there are no prescribed rules for the conduct of inquiries under the Electricity Act. Procedures to be followed, matter for the discretion of the reporter. In this case, we'll be dealing with the inquiry in accordance with the Code of Practice for Electricity Cases, which is available to view on the DP site, and again I'll include a link to that in my notes of the meeting. Essentially, the approach allows flexible procedures to be adopted. Each issue can be dealt with by the most appropriate method of examination. This could be by way of an inquiry session, hearing session, and the exchange of further written submissions. Some issues, sufficient information will already be before the inquiry. No further procedures will need to be required. I'll explain the differences between these procedures later on in the meeting. When I write my report to Scottish ministers, I will be taking account of all the environmental information submitted by the applicant, together with all the consultation responses, the letters of representation that have already been lodged. The type of procedure that we will follow, or the absence of any further procedure, not an indication of the importance of a particular issue. Are there any questions on the code of practice? Now, item 4 is my provisional assessment of the main issues to be addressed at the inquiry and those requiring further procedure. My provisional assessment of the main issues to be addressed in my report to the ministers and those requiring further procedure is summarised in the appendix attached to the agenda. And firstly, I wanted to ask the parties whether they think that is a good list of topics to be discussed at the inquiry, or is anything missing from that list? So perhaps, Mr. Innes, I could ask you first comments on the list of topics.
Yes, Colin is on behalf of the applicant. No, sir, we agree with your list of topics and agree to the methods of dealing with the matters. I would say that we've already had discussions with the council, and in those discussions we're keen to progress insofar as we can, as much agreement to make these sessions as effective as possible. And those discussions have already commenced, and we're confident that collectively we can narrow the issues that you've raised further to ensure that any oral procedure is focused in on issues that generally are in dispute, as opposed to having a general discussion about them. And as I say, those discussions are already underway, and both the applicant and the council appear very willing to make as much progress on these matters as possible. So yes, the pre-examination agenda has been very helpful, and it has stimulated that conversation already in terms of how we would help to respond to the matters that you've raised, sir. But in terms of the topics and the proposed means of determining or looking at the matters through the process, the applicant is content with what you propose.
That's good to hear. Thank you very much. Council.
Thank you, sir. Ewan Brown for the council. Yes, the council agrees, sir, that this is a good list of topics which reflects the issues which will come up for consideration. One point I should make at this stage is the council has now retained a landscape expert, and he is starting work on reviewing the application. And until that work is complete, sir, the council wishes to reserve its position in relation to the viewpoints which will come up for consideration. Mr. Innes has mentioned the discussion which has taken place already between the council and the applicant. That has worked well so far, and it's certainly the intention of the council to continue to liaise with the applicant to identify matters which are capable of being agreed, so that the inquiry can focus on the issues which are properly in dispute between the parties.
Okay, well, thank you very much, Mr. Brown. For the Community Council, Mr. Cleffin.
Andrew, thank you very much indeed. I'm sorry, I'm new to these proceedings, so you'll excuse me if I go a little slower this time. Andrew, can I just check with you? In your preamble, you mentioned the number and heights of the turbines. Those are not the information I had. I've seen some additional information which indicates they're going to be lower than the figures you read out.
I've taken that description from the additional information that was submitted
Oh, have you?
Application.
Then that's not the additional information I've got. I don't know whether I could.
Well, I can stand corrected, but I'll certainly ask Mr. Innes if he could confirm that from the applicant's point of view.
Yes, I've prepared on the basis of the position statement that we submitted, and no doubt that's the same information that you have. But if there's any doubt about the matter, we'll double check it and put a short note into to you so that it can be circulated to Mr. Clapham so that he's clear on the matter, because we don't want the matter to proceed on any ambiguities whatsoever.
Okay, thank you very much. It's just that the additional information I've got were not the figures that Andrew read out right at the start of the meeting. Thanks very much. So if I could understand properly then about the agenda for the pre-inquiry, when you've written no further procedure, does that mean that those issues are resolved and that there'll be no further discussion on that?
What I've said in the note is that there's information that was submitted with the application. Council have made comment on those in its report of handling to their committees, and my provisional assessment is that I think there's sufficient information before me on the range of subjects for me to come to a conclusion and make a recommendation to ministers.
Okay, I understand.
Further on in the agenda, we'll come on to discuss further written submissions. It is open to parties to make further submissions on those topics. I suppose the point I'm making here is that I feel that we can deal with those matters by an exchange of written submissions rather than have an oral process, whether it's a formal inquiry session or a hearing session.
Okay, I think I understand now. Thank you very much indeed. So I think that clarifies it to me, because the community council had raised some concerns which you had down there as no further procedure. But I think I understand now that indeed we've entered a written submission, and that will be taken into account in the inquiry. So I think I have nothing more. Thank you very much indeed, Andrew. I'm sorry to slow you up.
Mr. Cole, is there any comment?
As well, I'm new to this. This is the first one of these that I've been in, so really I'm just here to ensure that the voice of the local community is heard, and certainly my voice, and it has been already submitted in writing.
I should just say for the benefit of Mr. Clapham, yourself, Mr. Kilford, I will, as we move through the meeting, do come to discuss what's involved in inquiry sessions, hearing sessions. I will explain what that involves for those that are unfamiliar, haven't been involved in this kind of process. So hopefully by the end of the meeting, you should have all the information at your disposal to be able to prepare for. But what you just said, then I have to take it that you're happy with that list of topics and that there's nothing to be added.
Yes, I'm fine with that.
Okay. And Mr. Kilford.
I think my main concern is covered under residential visual amenity, which is obviously how the thing will look to me. One question, should the noise side of the impact of the wind farm be included in here somewhere as well?
Well, I have listed noise as a topic.
Right.
My initial view is that there's no further procedure required on the issue of, like I said before, I do have the information contained in the application. I have the comments from the Aberdeenshire Council. I had your representation, and my provisional assessment is that taking that all together, I think there's enough information before me to be able to conclusion on that matter and present my findings to ministers in my report.
Yeah, okay, thank you for that clarification.
What I'd like to do now is to get the views of the parties on the suggested procedures for each topic. and the issues to be addressed. And we've touched a little bit on that already. When it comes to landscape and visual impact, having reviewed the application, I consider the evidence presented by the applicant and challenged by the council and others that this is best tested through an inquiry session. I can ask for the comments of the applicants on this matter first before moving to the council and to others. So, Mr. Innes.
Yes, comments on behalf of the applicant. Yes, we agree that the landscape and visual matters are critical to the determination of this application, and it is the foundation of the main part of the council's objection to the application. And given that position, we feel that there is sufficient difference that should be explored between what now appears to be potentially different professional witnesses, and we'd wish the opportunity to ensure that that was properly considered, evaluated, and all the context is properly tested. I would say that even though we disagree, we will in the run-up again seek to try in relation to landscape and visual matters agree as much of the information as we can to ensure that when we get to any session, that the focus is on, again, on the areas of disagreement, and we're not trawling over matters that are effectively baseline information and effect. We should find out where we agree and where we don't agree, and then it may well be that the balance of issues is around questions of the overall impact of the scheme and how it fits. And clearly, that is a matter which I think it would probably be best be tested by expert witnesses giving their evidence.
Mr. Brown.
Thank you, sir. Yes, sir, the council agrees that the landscape and visual impact is best dealt with through an inquiry session. Again, echoing Mr. Innes's comments on that, the council will endeavour to agree what can be agreed with the applicant so that the inquiry session can focus on the matters in issue. One of the points I should indicate, sir, is that with the council bringing on their landscape expert, one of the things he'll be asked to do is to consider the aviation lighting issue. And I don't wish to take you out of turn, sir, in your order, but I thought I should perhaps indicate at this stage that the council's considering that aspect also with its expert.
Okay, well, thank you for that. Yes, I did have make reference to aviation lighting, and perhaps we can talk about that well agenda. So, but for now, thank you very much for that. Cleffin, the suggestion that we deal with landscape and visual impact issues by way of an inquiry session. Is this something that the Community Council would agree? I can't hear you.
Oh, sorry, press the button twice. Sorry, that's fine by me, Andrew. We're quite happy for it to be dealt with by an inquiry session.
Then Mr. Cole, and then Mr. Guilford.
I agree. It should be dealt with by the inquiry session, as long as local concerns are taken into consideration as well.
Guilford.
Yeah, I echo that. I think that's appropriate. Obviously, on the provision that we're able to provide some input to that process.
Indeed, yes, and again, I'll say a little bit more about that as we agenda. With regard to planning policy, my suggestion is that national and local planning and renewable energy policy best dealt with at a hearing session. I've listed the matters I'd like to discuss on a note to the agenda, and what I would say here is that it would be my intention to issue detailed agenda with specific questions to assist me preparation of my report. So again, I'll probably start with Mr. Innes. Can I ask you for your comments on the suggestion that we deal with planning policy and energy matters by way of a hearing session?
Yes, Colin is on behalf of the applicant. I mean, this is an area where the vast majority of material as to what is and isn't relevant should be capable of agreement. It then becomes slightly nuanced in terms of the weight to be attached to various material and the findings. So it therefore is very well suited to a hearing session. In terms of the topic matters that you listed out and sort of some of the context, we probably would have added in, you know, there are statutory provisions such as the Electricity Act and the climate change legislation, and also specific energy policy matters, which all are potentially relevant as well under that planning and renewable energy policy. It's also got, as I say, it also has legal aspects to it as well. And I think, you know, sometimes at a public inquiry, it is left as a sort of closing submissions before the legal submissions are made. I think in this context, they do have a bearing on how it all fits together in terms of both the Electricity Act, but also in terms of the climate change legislation and how that is subsequently relates to policy development. So it would be our intention to cover those core areas of the legislation and context as part of that session. And again, we'd be looking to agree quite a lot of the base material with the council, and hopefully that would be a relatively straightforward session, picking up any differences in nuance probably more than anything else. And that's really why it makes it really very suitable for a hearing session. Thank you.
Brown, your comments.
Thank you, sir. Yes, the topic is amenable to a hearing session. Again, the council will try to agree the baseline material with the applicant. The list of topics covered in that baseline material, I expect, will be longer than you've identified, sir, for the reasons Mr. Innes has explained. And with questions from yourself, sir, there should be a focused discussion at the hearing session on the nuance, as Mr. Innes has described it, of the application of the material.
For the Community Council, yes, your thoughts. I will, in a few moments, actually describe how I tend to, or what's certainly involved in an inquiry and a session. But let's just say, for the time being, it's something which is less informal. It's more of a structured discussion than a session where witnesses are questioned and cross-examined by other parties of opposed.
Yes, thank you, Andrew. I think that's fine with the Community Council in terms of when we get up to those areas of legislation and planning policy. We would, of course, expect to be following the lead from Aberdeenshire Council. So the Community Council probably won't worry about that so much.
Mr. Cole.
Yeah, again, agreed. You know, I know very little on the legislation and the legal side of things. I do think the nuances are very important because it's the nuances that are affecting the people that are directly affected by this application.
Ilford.
Yeah, also happy to leave it to those that are more knowledgeable on the topic.
Then think about planning conditions. I'm also suggesting that we discuss a draft set of conditions and any obligations that may be at a hearing session. Again, I'll say for the benefit of the Community Council and others less familiar with this process that this shouldn't infer any intention on my part to recommend that consent should be granted to the application. Rather, it's for the benefit of Scottish ministers when they come to consider my report to assist them should they decide to grant consent. As I note with the agenda, the expectation is the applicant will liaise with the council and other relevant interests to draft a set of conditions and present them in a statement, highlighting points of disagreement and any alternative positions adopted by the parties. So perhaps again, turning to you first, Mr. Innes, is any comments from the applicant on the suggestion that we deal with conditions through a hearing session?
Colin, on behalf of the applicant, just to say, no, sir, we think that's entirely suitable. We would be looking at the energy consents standard set of conditions. They are standard, but they do need to have thought to the actual development that's being considered, and any adaptations to that will be proposed in light of the various consultation responses that have been received from the various formal statutory consultees and others, and we would then work with the council to reach as much agreement on the content of that as possible. I would hope that there should be a relatively high level of agreement, hopefully, and that again would be hopefully a relatively short session dealing with whatever we were not able to agree on, which is usually aspects of wording of particular conditions, and again, really highly suited to a discussion, and would work effectively as a means of resolving whatever was outstanding. So again, we agree with what you've proposed, sir. Thank you.
Mr. Brown, for the council.
Thank you, sir. Yes, the council agrees that a hearing session for planning conditions would be appropriate, and again, it's anticipated there should be a high level of agreement between the applicant and the council on conditions.
Yes, the Community Council agrees with that, Andrew. That's fine.
Mr. Cole?
Agreed.
Mr. Kilford?
Yep, fine as well.
Just turning to access and public rights of way, there is an outstanding objection from Scotways. Concerns being raised by the Community Council and others on this matter. As I mentioned earlier, my provisional assessment is that this matter could be dealt with by way of a written submission. Just wonder whether you would agree with that, Mr. Innes, first, and then I'll move on to the council and invite the Community Council to contribute.
Yes, I think this is a matter which could easily be resolved in terms of the different positions of parties by an exchange of written submissions, as opposed to having to hear formal evidence from expert witnesses. It's essentially a matter of fact, the distances to public rights of way, and the consequences of that are a matter we're happy to deal with by written submission.
Mr. Brown?
Yes, sir. The council would also be content to deal with that by way of written submission.
Yes, the Community Council is content with that. Thank you.
I have no real issue with that.
Finally, Mr. Kilford.
Yep, I'm fine with that as well.
Thank you. With regard to all other topics, some of which have been mentioned in representations, as I've said before, I think I have sufficient information to be able to write my report. However, it is open to parties to make further written submissions on the topics that have been identified in the appendix. And I just wonder if there are any parties here wishing to make further written submissions. I'll probably start with you, Mr. Clapham, from the Community Council, Mr. Cole, Mr. Kilford, before I ask the applicants in council to comment. Are there other topics there that you would wish to make some further submissions?
No, I think everything's been covered. Thank you. There was only one comment I wanted to make, and that was, in fact, it came up just earlier on in this meeting about aviation lighting. I don't know whether we could just expand the noise section to include noise and light.
Cole, any comments on the, want to make some further submissions on those topics I've identified?
No, I've already made my concerns known in writing.
Mr. Kilford.
I think I'm in the same position as well. I've already made my or submitted my views, so I think that that covers it.
Mr. Innes, comment on what you've heard from.
Yeah, comments on behalf of the applicant, just to say that aviation lighting looks like it's going to be a topic that will be discussed during the landscape and visual session. So it is a topic that will be canvassed, and there'll be discussion of the full extent of it, etc. So it will be a topic that is considered through the process.
See you have your hand raised, Mr. Cole. Say.
Yeah, thank you. I would like it noted that during the meetings around this in the Auchenblay Town Hall, I had specifically asked if aviation lighting would be on these, and was told by the representatives from the applicant that indeed there wouldn't be any. Just like that noted.
Voice broke then. So you said, oh, by the.
This was raised during the open day in the Auchenblay Community Hall. And I had specifically asked if, because of the height of these turbines, that there would be aviation lighting, and was told verbally by the representatives of the applicant there and then that there wouldn't be. So this is different from what I was told during the actual meeting itself.
But as you just heard, you know, the expectation is that this is a matter that will be addressed in the inquiry session, and opportunity to ask questions. You know,
I'm sorry, I never heard you.
I'm saying the topic, as you heard from Mr. Innes, the topic is likely to be discussed and addressed in the inquiry session. So there will be an opportunity to participate in that session and you know, ask questions of the witnesses.
Yeah, thank you.
Sorry, Mr. Innes, had you finished? Oh.
No, I was just going to say that I did check the additional information and the position statement, and it was for 6 turbines, we're up to 149.9, and the importance of that height is obviously that no aviation lighting is required because it's not an obstacle of 150 meters and over. But there are 2 turbines of base to tip to 200, and 2 turbines up to 180 in the position of the scheme put forward as part of the additional information. And for the purposes of Mr. Cole, irrespective of whether there's mitigation applied, there will be aviation lighting having to be fitted in relation to those turbines that are over 150 meters and over currently. That's the current position. So, and we've addressed that in the environmental information that's been submitted, and obviously we'll address it in evidence in relation to the inquiry session relating to landscape and vision.
Thank you. Mr. Brown, yes.
Thank you, sir. Yes, it does seem that this topic will have to go to an inquiry session for landscape and visual.
Much. I'm sure we can deal with this next item very briefly, actually. It's the position of the Ministry of Defence. And I wondered if, for the benefit of all parties, if I could ask the applicant just to clarify the position of the MOD, which I understand has withdrawn its objection to the application, subject to suitable conditions being attached to a consent, you know, should ministers decide to grant the application.
Collins, on behalf of the applicant, yes, sir. In terms of both the original scheme and the additional scheme, there were original objections submitted by the MOD. They had concerns relating to potential impacts on radar. I'm pleased to say that following on from discussions, those matters have now been resolved, and effectively the MOD have withdrawn their objections subject to the inclusion of conditions, which again we will put forward as part of the agreed conditions. We'll put forward with the council, and we'll identify which ones are requested by the MOD, so there's a clear link between the correspondence and those conditions.
Very much.
Thank you.
Item 6, it's about the participation of parties in the procedures that we've just spoken about. And I'll take a little bit of time here to explain to Mr. Klepper, Mr. Cole, Mr. Kilford what's involved in these procedures. Inquiry sessions. Each party taking part will be invited to present evidence in chief in turn, which is subject to cross-examination by those of opposing view, following which there's an opportunity for examination. Generally, as always, friendly cross-examination between parties of the same side of the argument is not permitted. Questions of clarification are acceptable. Irrelevant or repetitious evidence or cross-examination is not permitted. Now, usually parties are legally represented and lawyers question or cross-examine the witnesses, although it's not essential to be represented by a lawyer. And I'll also have questions for the witnesses. So inquiry sessions are formal proceedings and particularly suited, as Mr. Innes mentioned earlier, they're suited to topics where there's a lot of technical evidence and there's differences of professional opinion. That's generally why we use formal procedure in technical matter. Hearing sessions, as I mentioned, they take the form of a structured discussion between parties involved. I will lead that discussion. There's no formal leading of evidence or cross-examination. And I'll prepare an agenda for each hearing session in advance with a list of the topics for discussion, questions that I tend to ask. Everyone is to advise me that they want to take part, can participate in one or both of the hearing sessions, although I think you've given an indication there that perhaps Council and wish to participate in the policy session. There's no need for legal representation session, although the lawyers of the parties can take part in the discussions. Generally, hearing sessions are more informal than inquiry sessions and are particularly suited for topics where there's a kind of a difference of opinion on less technical issues, like, for example, the interpretation of Now, once all the evidence has been heard, parties are invited to make closing submissions, and closing submissions should address the party's position on all aspects of the proposal, not just those that have been subject to process. What I'm going to say here is, whilst there may be public interest that would justify reading those submissions at the close of the inquiry, I think it's worth considering parties would be content with an exchange after the oral proceedings have come to a close. This would have the advantage of parties being able to have time to reflect on the evidence before preparing their closing submissions. The submission would be lodged in the same sequence as if they were being presented orally, but the objectors would submit their submissions, then the council, the supporters of the application, and finally the applicant submission. Closing submission should also be circulated to parties presenting, so circulated to those parties presenting closing statements, and will be posted on the DPA website as well. And we would agree the dates at the end of the inquiry session, at the end of the oral proceedings, I should say. So, do you have any questions about those inquiry or hearing or preparation of closing submissions? Perhaps I'll ask Mr. Clapham first.
Thank you, Andrew. That sounds relatively complicated, but I think I got the general gist that we would be able to attend and listen to the discussions at both the inquiry and at the hearings, and then indeed make I think from our point of view, probably quite a short closing submission in writing at a few days later. Is that right?
That's right. Yes.
Okay, that'll be fine with us.
Cole?
Yes, that's understood from my side.
Guildford?
Yeah, I understand that as well. So I think that's fine with me.
As I mentioned in my notes, the DPA is keen to find the best way for objectors to make a meaningful contribution to proceedings. I certainly don't want to discourage anyone from giving evidence at the inquiry, but we do strongly recommend that individuals join together where they share the same point of view, which I note that is the case in representations that I've read this application. So this allows the presentation of a coordinated case, avoids unnecessary duplication of effort, enables a pooling of resources. And with that in mind, I wanted to discuss the participation in the inquiry session on landscape and visual matters. Basically what I'm saying here is that if you feel as though you're sharing similar views, you're on the same side of the argument, whether you could kind of coalesce. So in this instance, we do have a representative body in the form of the Community Council. It's whether you would give some consideration perhaps to joining with the Community Council, or it's perfectly fine if you thing and you don't necessarily want to ally yourself with the community. So that's really what I'm going to be trying to explore in this next section of the. So when it comes to the inquiry session, I'm certainly expecting the applicant and the council to take part. And I wonder what you feel, Mr. Clapham, about opening up your participation to others being involved. And I'll ask Mr. Cole and Mr. Kilford how they feel about that.
That would be fine with us, Andrew. I'd be perfectly happy for either myself or somebody else to represent the Fuchside Community Council, and I think that would probably include Rob Strawn. He's not here today. Mr. Strachan, you mentioned him this morning, and if Mr. Cole and Mr. Kilford would be happy to coalesce together, we'd be very glad to do so.
Mr. Cole, how do you feel about that?
So I'm happy to do that.
Kilford?
I've actually got some reservations. I think, without being too familiar with the Fuchside Council and the aspect of it they consider, I think there is a need to have the residents in the Chapelton area on that side of the wind farm directly involved in the process. So I would like to have our input, albeit that we, most of us share the same viewpoint, but there should be a separate input from the Chapelton area.
Yeah, that's perfectly fine. Happy to accommodate that.
I can see. Sorry, it's Ross Cleffin speaking. I can see that because we are just on two different sides of the watershed. We have quite different aspects with or quite different views, at least, of the Fetteresso wind farm, and so I can understand why that would be.
And at the inquiry session, it would be my intention to hear the evidence of the applicant first, followed by the council, then the community council, and then Mr. Kilford and any other individuals. I'm assuming that sequence is acceptable to the parties. Mr. Innes, yes?
Absolutely, sir. I'm very comfortable with that. Thank you.
Brown, is that sequence acceptable to you?
Yes, that's acceptable, sir.
That's fine with us.
Now turning to the hearing session on policy, sessions I should say, on policy and conditions. Again, I would expect the applicant and the council to participate in that. I think you've already suggested that you may not, Mr. Clapham, but perhaps I could hear from you formally on that matter. So would it be the Community Council's position not to sit around the table and discuss those?
Yes, I think that's true. I think from what I've heard so far today, we would not need to come on the planning policy. I think we're quite happy to be led by Aberdeenshire Council on that issue.
Mr. Cole.
Yes, yes, I would be led with those that are technically more proficient.
Mr. Kilford?
Yeah, I agree with that as well.
Yes, just turning to item 7 now. Just thinking about some dates and the duration of the inquiry. Helpful to have the timetable in front of you. Some discussion on availability. I think there is agreement that the inquiry could commence in early November, and I've based the timetable on a 1st or 2nd November start, depending on whether we hold it virtually or whether we are in person. And I just wanted to get confirmation from each party that a 1st or a 2nd November start would be acceptable. Mr. Innes.
Sorry, the button wouldn't work. Colin Innes on behalf of the applicant. Yes, either a 1st or 2nd November inquiry start would be suitable for the applicants. We anticipate that the inquiry session in relation to landscape and visual matters should probably provisionally be timetabled for a couple of days. And in the context of both the planning policy hearing and the conditions, our view is that that could probably be completed in a day, probably with one being done in the morning and one being done in the afternoon. So we think probably it is likely that 3 days of procedure would probably be sufficient for the case, given the number of parties that are participating and the topics being considered. That's our provisional assessment. Other parties may have a different view, but that was our initial thinking in terms of looking at the timetabling and how matters might progress.
Okay, that's very good. Mr. Brown, Council.
Thank you, sir. Yes, a start date of the 1st or 2nd of November suits the council. Picking up on Mr. Innes's estimates of time, yes, a couple of days for landscape and visual matters would seem to be appropriate, and given the approach which the council and the applicant has adopted to date on planning conditions and policy, then 1 day for both hearing sessions would probably be sufficient. But those again are provisional view. It may be necessary to come to a 4th day.
For the council.
Yes, the Fuchside Council agrees with that.
Paul?
I have no issues with that.
Okay, so Mr. Kilford, is it a November, early November start convenient for you?
Yeah, November works for me as well.
Now, if we are able to hold person inquiry, which I think everybody would perhaps think was preferable, sensible, even at this stage, to give some thought to a suitable venue, bearing in mind the guidance set out in the notes, which I referred to earlier. I have to confess, I'm unfamiliar with this part of Aberdeenshire, so I'm perhaps open to parties to perhaps some suggestions as to where we might hold person. Mr. Innes, I don't know if you're aware of anywhere in particular.
Well, I've done inquiries both in Stonehaven, but I haven't done one in Bankery. And as we sit probably on the divide, one part of the hill probably sits across the other side, and therefore you could hold it in probably either and say that they were both relatively local to the position. I'm not. I mean, my recollection from hotel accommodation in Stonehaven was it was not that large, and it all depends on I think in terms of even if we're projecting forward to November and considering whether there are rules in place for distancing and everything else, the key is the size of the room. But given the number of parties, we could probably get away with if a venue has a hospitality space that often works during the week, and whether they have that sort of arrangement, particularly having done quite a lot of matters up in Aberdeenshire, that often that has been used. It's been effectively the hospitality industry's sort of best description is their dancing suite. There's usually a bar in the venue, etc. But that sort of has been where certainly we've done stuff in the past. But clearly the council may have either a venue in mind or a preference. And I think equally it's worth hearing from local residents, because they might have an idea of we're looking for something with a relatively large function suite. Is there something nearby that you think would be most suitable, and where it fits? The applicants obviously relatively relaxed as to where it actually takes place. I think the key is having a venue which perhaps had some acknowledgement that there might be some restrictions, but that we had a freer position than we had today.
Mr. Brown, perhaps you can help.
Thank you, sir. Yes, well, the council might be in a good position to assist with identification of suitable venue. I understand that the council has already looked into whether the council chambers in Stonehaven might be able to offer suitable accommodation, subject to availability and checking the size of the main hall, just in case there are still some social distancing requirements in place, and making sure that there are breakout rooms for those who may require those.
Mr. Cleffam.
We could offer the use of the Strawn Village Hall. I haven't actually looked at the booking sheet, but I'm pretty sure it will be available if indeed you needed it. It's relatively basic, I would say. We just have a one large room. We can make tea and coffee, but I don't think I'd call it a function suite. And we just have the one breakout room. So we'd be glad to offer that, but perhaps it's perhaps not quite what you're used to.
It will be November. Is it warm?
Oh yeah, it'll be warm enough. Yeah.
Super. Mr. Cole, Mr. Kilford, any thoughts? Are you?
Temperature is an issue. I could suggest why. But on a serious note, I travel for work, so my personal attendance, it might not happen. So as long as there's still a facility to dial in or be remotely involved.
Okay. Point.
And I'm happy to travel within reason in the local area to any suitable venue.
That's just a final word on this. Would be my intention to start inquiry session before moving on to the hearing sessions. I say I would hope we could move through the topics without any breaks. So, and again, I'll include a timetable of the meeting. Right, item 8. This is the timetable for the submission of documents, written submissions and statements and so on. Again, perhaps Mr. Innes and Mr. Brown will forgive me. I'll perhaps explain a little bit about what's involved in the submission of inquiry statements and precognitions for these sessions. So there are a number of written exchanges that will need to take place before the inquiry and the hearing sessions commence to ensure that each party is fully aware of the case being made by those on the other side of the argument. Parties taking part in the oral procedures will therefore need to disclose the cases they intend to lead in advance. And again, I've prepared some notes with the agenda, which might be of help to those, say, that are familiar with this process. In an attempt to cut down the time between the receipt of an application and an inquiry, I would just add here that the process and timescales referred to might differ from those that you might anyone be familiar with. So just a little bit about hearing, about statements, particularly inquiry statements. For those taking part in the inquiry session, statements will need to be lodged, and looking at the timetable that I've circulated last week, statements would need to be lodged by the 6th of September. That's 8 weeks in advance of a 1st of November inquiry start date. And the statement should outline the case to be argued, should list all the documents that are going to be relied upon, and the witnesses who are going to speak at the inquiry, including the topics that each one cover. It would also be helpful to know who will be in the case and cross-examination witnesses. Now, precognitions, this is a statement which each person presenting evidence at the inquiry is required to submit. Again, these are to be lodged by the 18th of October, draft timetable that I've prepared. That would be 2 weeks in advance of the inquiry start date. A precognition should be concise, should provide a clear summary of the evidence of the witnesses, and they should be no more than 2,000 words long. In the interest of efficiency, each precognition should be drafted so as to allow me to incorporate them directly into my report for ministers. And if there's any evidence to the contrary, points conceded in cross-examination or in closing submissions, I'll deal with those in my conclusions. Come to the hearings and hearing statements. Again, these should be lodged by the 6th of September. Again, that's 8 weeks before the start dates of the inquiry. The statement should provide full details of the case to be put forward. Again, list the documents that are going to be referred to, specify who is going to be taking part. We've already had some discussion on conditions. Again, these should be agreed between the parties as far as reasonable possible, and I'm good things in that regard. And as indicated in my notes, I would like the applicant to commence that process, which I think Mr. Innes has indicated that would be the case. The first draft of conditions with initial responses from each party, I'm suggesting should be lodged by the 2nd of July. That's 6 weeks from today. And a second draft of the proposed conditions to be lodged by the 6th of September, and that's 6 weeks before the inquiry start. And this should be in the form of a written statement, again identifying areas of disagreement and any alternative approaches that parties wish to pursue. Now, documents play a very important part in the inquiry process. A first draft of the core document list, I'm suggesting here, should be submitted by the 2nd of July, so that's 6 weeks from today. All hearing inquiry documents to be lodged on the 20th of September, 6 weeks in advance of the inquiry. I'm suggesting here the applicant should liaise with the council and other parties to produce a single core documents list, decide who should produce what. There really isn't any need to duplicate documents. To assist the inquiry, this has worked very well elsewhere. To assist the inquiry, I would ask the applicant to upload the documents onto a single memory stick by each party participating in the inquiry. And in this regard, my office will be happy to assist this exercise by making use of our core document library, advising on numbering conventions. Quite happy to help in that regard. Spoken about further written submissions. I will identify matters subject to further written submissions by note of the meeting. Written submissions should be lodged by the 2nd of July, 6 weeks from today. Any responses to those submissions should be lodged by others 14 days after, so that would be by the 16th. Finally, a word on statements of agreement, and again, hear what Mr. Innes and Mr. Brown have said. In order to allow the inquiry to focus on matters in dispute, final statements of agreement, I'm suggesting here, should be prepared and lodged by the 9th of July. That would be 7 weeks. I'd like all statements, written submissions and documents and precognitions to be submitted using Word. So that would be okay with everybody. And that allow me just to kind of, I suppose it's been said into my report. The only exception being any large format plans and or visualizations, which I would expect to be produced in paper. Okay, so there's a lot there. Perhaps I could ask you, Mr. Innes, to if you have any comments on that timetable.
Sorry. Yes, thank you, sir. It's extremely helpful to have the timetable. In terms of timing, 9th of July for the statement of agreed matters looks quite tight if the council have just appointed a landscape architect. They'll no doubt be doing their work and reporting back, etc. We can aim to achieve, because I think that's one of the areas where I'm sure on planning policy, etc., we'll be able to get things moving much quicker. I'm just flagging that one might be slightly later. I would anticipate if there's a delay there, and I still think it would be very well worth pursuing, because it essentially means that baseline level of agreement means that there is less to do in terms of the context of the inquiry. So I'd just flag that. I think we'll be able to reach statements of agreed matters earlier on those other topics, but we'll obviously endeavour to do whatever we can. But given that the council have just appointed a landscape architect, that looks like that might be quite tight. The only other comment in this timetable is the potential for a second PEM, which would essentially be a sort of checking point in terms of the process as to where we are in terms of covered rules, etc. Our thought that probably that might be best held after the summer, probably more into the sort of beginning of September, would be a more appropriate time, because we'll have a clearer indication of where things stand at that time. Whereas July, in 6 weeks' time, we're probably still not quite sure and still progressing, having unlocked. So that would be the only session. And the final point, and I know this is often an important one for many local people, is that also as well as this formal process, there is a site inspection process where you get the opportunity to go and visit locations. We'll again liaise with the council. There may well be many locations where we agree that there is no need to be essentially accompanied, and that's a matter whereby you can go to the viewpoints, they're accessible, etc. But there may be aspects, for example, where on site it can save a lot of time if a site inspection is arranged and access can be given in a structured fashion. And equally, there may be other parties who want to show you things at particular locations, and that's all part of the process as well. And it was just to sort of have a process. We'd sort of obviously seek to agree matters with the council, but clearly there'd be a matter for the community council, and those individuals who've expressed a view of participating in the process may well want you to go and visit their particular properties. So that's all probably a matter. It's a process to be developed, but obviously as an add-on to the matters on the agenda. But apart from that, we think the timetabling is effective and will enable proper preparation of fair notice.
Thank you for that. I take your point about the statement of agreement on landscape and visual matters, and I'll ask Mr. Brown to comment on that in a moment. Date for the second pre-examination meeting. I think what I had in mind there was perhaps the difficulty of finding suitable accommodation so close.
Yes.
And I suppose it's a bit of a trade-off, isn't it? Wanting to know where we are with COVID and
yes,
and doing the practical stuff, trying to
I was presuming that you probably proceed on the basis of its an inquiry in person, but on the proviso that there is a continued risk that may not happen. And obviously very grateful to the council for looking at council accommodation, because often that can work very effectively. I think the one issue in any venue is it's always beneficial to at least have some element of Wi-Fi connection if at all possible. But we fully accept that can't always be guaranteed. But it obviously is beneficial if we can have Wi-Fi, and I know there may be other reasons why it's beneficial for Wi-Fi for DPA reasons. But apart from that, we had anticipated that there might be a provisional booking, and it would be a question of just a stop check to see actually, things are not progressing, and it still looks likely, therefore, that actually this type of meeting would probably have to proceed virtually. So that was really how we were anticipating that sort of second pre-examination meeting. Is really a question of when you feel it's appropriate to make that final decision. And I think the fundamental point is there is no final decision, because that whole point is things can change over relatively short periods of time. And given the geographical spread of all the people that are here, that any number of people may or may not be able to move at any particular point in time. So I think it really needs to be a backup of a virtual there, and whilst also maintaining the possibility of a genuine in-person inquiry if at all possible.
Points very well made. Thank you.
Thank you.
Perhaps a bit appropriate to hear from you, Mr. Brown.
Thank you, sir. First of all, with regard to the statement of agreed matters, the council would welcome the opportunity to have an extension of the period which you indicated, sir, until the end of July. That should give sufficient time to allow our expert to input into that matter, and equally provide sufficient time at the other side of that before the inquiry starts. With regard to a second pre-inquiry meeting, yes, the council would welcome such a meeting in order to take stock of what has been achieved through the statement of agreed matters and indeed agreement on the conditions. That would be useful. I appreciate, sir, you raised a question about accommodation. Now, what I can say on that, if it assists, is that in the course of our call this morning, I have an indication that, subject to making sure the council accommodation in Stonehaven would be suitable for any social distance requirements which may remain in November, that the accommodation is available and can be booked provisionally, sir. And if that assists, can I suggest, sir, that what happens is that the council verifies the extent of the accommodation available, and that it writes to your office within the next 14 days to confirm whether that accommodation would in fact suit the inquiry.
Very helpful. Thank you very much. That sounds good. And if you could do that, I'd be grateful. Thank you.
Certainly, sir.
Before we move on, Mr. Innes, I don't know if you're familiar with the accommodation in Stonehaven, or Mr. Clapham, if you have any comments on that.
I'm not familiar, but I've got no comments. I'm quite sure that Stonehaven can offer something better than we can.
Mr. Innes, any further comment on that?
I think it's very sensible. I think the only thing is DPA will have to be happy with the venue as well. So
yes,
you'll have to do your various due diligence and finding out the. But otherwise, that looks a very sensible location, and one that is very accessible.
Okay, well, thank you for that, Mr. Brown. Very helpful. Okay, we touched upon site inspections there. I was hoping that I might get up to do accompanied inspection sometime next month. Certainly looking at some, if not all, of the viewpoints referred to in the environmental statement. But I was also going to suggest, and again for the benefit of the Community Council and Mr. Collin, Mr. Kilford, it would be my intention, either during the inquiry or at the end of proceedings, to make an accompanied site inspection, which parties are able to attend, again subject to any restrictions that might be enforced at the time. But I was also going to say that if parties would find it helpful, I'd be happy to conduct an accompanied site inspection before the inquiry, make sure that I'm kind of looking at the right things. And then we could use the second inspection to deal with any specific matters that were raised at the inquiry. So I'm fairly flexible, and it's what parties think would work best. I think I'll go up next month in any event, just to familiarise myself with the site and the surroundings. But if you have any further thoughts, Mr. Innes, on how we might, whether there would be some benefit in doing an inspection immediately prior to the inquiry, and then having a perhaps more kind of focus inspection, accompanying inspection after the inquiry.
Yes, Collins will have the applicant. I think doing an inspection in advance of the inquiry is very sensible, but we do probably want to understand whether, I think the council's just appointed a landscape architect, we understand their responses, but equally, I mean, what we will do is perhaps feed back in after this meeting as to access to site and surrounds, and to see whether there is a value in an accompanied site inspection, and we'll come back to you. But ultimately, it's to ensure that you have the right information. And I think there is a lot of benefit in seeing a lot of the material and locations in advance of the public inquiry, and thus leaving only the extra bits for subsequent, if there were disputes or matters you want to go back to. But equally, well, I'll come back to on whether it needs to be accompanied or not. But we'll have a good consideration for that. What I don't want to do is just say now that it may or may not be. It may be actually relatively straightforward, or there may be aspects of some viewpoints or the site that are difficult. Certainly, my experience in other forestry contexts has been that there probably needs to be advance notice, and just in terms of risk assessments, etc. But we'll obviously find out the precise details and get back to your office with those. But certainly, if you're going up in the next month or so, that certainly makes sense in terms of it's better daylight, longer hours, you could achieve more. By the time we get to November up in Aberdeenshire, the days are getting a bit shorter, and that makes it more difficult to get around all the material throughout the day. So certainly we would encourage an early site inspection and not leaving it all till November, because it will be a much harder task. So we'll come back to you on that one if we may, and equally perhaps other parties will have views too, and it's important that they may have views on places they want you to see that perhaps weren't formal viewpoints. And I think it is important to recognise that within our environmental assessment, that we use viewpoints as being representative of the area of visibility, and it may not be from a specific location of the particular interest, but there may well be a viewpoint that represents that view and can be used as the proxy because it illustrates the view of the wind farm from that particular location. But there may well be other suggestions of parties of places they wish you to go. But certainly we'll come back as the applicant as to any formalities that are required or not, as the case may be in relation to the site and the surrounds.
Before I ask Mr. Brown to speak, I would say for the benefit of the Community Council and Mr. Cole and Mr. Guildford, normally what would happen is that I would invite the applicant to draw up an itinerary consultation with other parties for a site inspection, and we would spend some time going around looking at the points that people have raised that they would like me to see in particular. So it's not just what the applicant, the council would like me to see. Have an opportunity to kind of feed into the preparation of a itinerary. So Mr. Brown, for the council, thoughts on site inspection?
Yes, thank you, sir. Yes, I think it would be sensible to have an accompanied site visit before the inquiry starts and another after. I think it would make more sense for those involved in the inquiry when it comes to understanding the landscape and visual evidence.
Yes, I think we very much support an accompanied site inspection, and not just from the landscape and visual point of view, but also to go and really see the the ground itself, to go and see the peat bog, to see to see the marsh, to see the kind of ground that's going to be involved. So we'd very much support that.
Paul, any thoughts?
I support it fully, and I would also say that additional inspections should be held as a minimum at the residential properties that were highlighted as being significantly impacted in the applicant's own survey.
And Mr. Kilford.
Yeah, just to second what Mr. Cole just said, I think it's very difficult to capture the impact with photographs and trying to explain it that way and in correspondence. So site visit is by far the best way to view it and have a discussion.
Just a few miscellaneous items to mention now. Regarding the deposit of documents, obviously we're still.
So I was just going to.
I beg your pardon, sorry.
Yeah, I was just going to come back. I think what has to be made quite clear is that there are quite a lot of limitations on what can actually be done on a site inspection, with the difficulty that we end up potentially almost having a public inquiry, a public hearing session in the field. The site inspection is really only for pointing things out. There isn't really the opportunity to give evidence or debate evidence at a site inspection. It's to take the reporter to a particular location, and you can say what you want the reporter to take from it, but it's not really about having a debate on site about the merits. So it's very much a pointing out things that you want the reporter to particularly note from the site inspection. And therefore, I didn't want there to be any misunderstanding about people thinking that they could perhaps wait for a site inspection and discuss all the issues. If you want to put something into the process, it's got to be in writing. And the site inspection is really only for a discussion of things that you want to point out physically on the day. And that wouldn't want there to be any confusion or misunderstanding about that, or otherwise people might have waited to the site inspection to think that they could have the discussion and then would not have put what they wanted to put in. So I just wanted to make that point as a point of clarification, but not in any way to exclude people or people going to people's houses. For example, it's perfectly normal for somebody to say, I want you to come to my house to look at the impact of my particular property and to point things out. This is where the wind farm would be. This is where we have our particular room that looks out, or whatever. All those are perfectly acceptable point outs, but then it's the discussion that goes beyond the point out becomes difficult because it's then going to the merits. But I just wanted to make that point clear so that there wasn't any misunderstandings about people not having put a point forward and then feeling that the site inspection was not as perhaps as an open process as they felt it might have been.
Thank you very much, Ines, and quite right. Perhaps I should have said a bit more in my introduction to the topic, but I'll certainly make those points quite clear in the meeting. Mr. Cole, I see you have your hand raised. Yes.
Yes, sorry, it was just in addition to to what was said about the site inspections at residential properties, relating to this proposal. I think a thing that should also be taken into consideration is not just the proposal in itself, but the existing disruption and existing wind farms that already exist around those as a measure of what additional impact this application will have.
Yes, that's fine. Yeah. As I say, I'll perhaps make my note quite clear on what the purpose of the site inspection is and what we're able to go and see. So I'm happy to do that and make that quite clear in my notes. Any further comments on site inspections before? That's fine, thank you. Yes, we've spoken a little bit about the deposit of documents. Of course, the legislation, the Coronavirus Act 2020, still in place. If any statutory requirement to make documents physically available for public inspection might give rise to significant risk of transmission of the virus. Nonetheless, it remains necessary to place the documents on deposit for inspection by the public. Now, the view of the DPA is that this should be sufficient. It should be sufficient to give notice as to where the documents relating to the application can be viewed, albeit electronically. I think in previous cases, I think we've just had a link to the case files on the DPA website included on the council website or on the applicant's website, or indeed perhaps the council if you have a website. So I mean, if any parties have any views on this matter, Mr. Innes?
I think we should probably have a fallback in case the rules change. And I presume that normally it's council, a library or a council office is usually the selected venue on the basis of it can be accessed at office times and it's suitably controlled. I don't know whether the original ES was displayed or whatever, but I think it perhaps be sensible to have a provisional in case the rules change and we had to do it at short notice. But it would normally be a council office, I think it would be.
Mr. Brown?
Yes, sir. For the moment, I think that it has to be an online viewing platform which is used, but because the council's offices are actually closed to members of the public at the moment, as are its libraries. However, should the position change, sir, can I suggest that what happens is that the council writes to your office, say 7 days before the anticipated opening date, to advise you that the offices and libraries are being open to members of the public, at which point a decision can then be made about lodging the documentation for public inspection. That would be the fallback position which Mr. Innes outlined earlier.
Yep.
Any other comments on?
No, from the community council's point of view, we're perfectly happy for the files to be visible on the DPA website.
So about contact. All contact with the DPA should be through my colleague Morag Smith. She's the case officer for this application. Contact details are on the agenda, but I'll include them again in to the meeting. An important thing to clarify here. Presuming that you're all content to be contacted on the email addresses that you provided in preparation for this meeting. I did note that some of you actually have used personal I just wanted to make sure that everybody's content for their personal email address to be circulated to others to allow the necessary exchange of documents to take place. Now, if that's not the case and you're not content, it would be good to hear how you wish to be contacted. So I'll direct this first at say Mr. Cole. I think you used your personal email address, and Mr. Kilford.
Yeah, that's correct. I've got no problem anyone contacting me as long as it's used for this matter.
Mr. Kilford?
And I'm the same, no objection.
Mr. Clapham, I can't recall whether you used a personal email address or whether the Community Council has a dedicated account.
We do have a dedicated account, but I would prefer it to be my personal address, because then it'll come directly to me.
Mr. Innes and Mr. Brown, I think they're all business accounts, aren't they?
Yes, comments above. That's correct, sir. So we're happy. I think the only caveat I would say is that the volume of material can be quite high, and that's the only warning us that if you're taking all these documents, there is quite a lot in terms of generally of size of documents coming in and everything else, and that is why effectively within the process that we've got a provision whereby a memory stick is collated for all the documents rather than them all being sent in a batch of emails that usually bring your system down. So we will endeavour to, if that's what fits. So we'd probably need an address for that. And if you're happy for your address, I think it's through the DPA, they make that address available to the applicant, and we send you a stick of the relevant documentation. That is how it's been working to essentially avoid your inbox getting inundated, because if you take the whole inquiry documents through an inbox, it can be challenging, and certainly our IT department doesn't like it. So that's how we deal with that. But in terms of other material that you want to see, like the precognitions, they'd be circulated on the day by email, and you get them instantly. It's just the bulk volume of documentation that really is the documents is the issue, where it becomes fairly unmanageable to do it by way of email. But everything else would be circulated by email. Thank you.
Yeah, that's fine. That's fine. So I'll provide my address for the large amounts of documentation, and then the email address for short stuff.
Comment on that, Mr. Brown?
No, sir. The email addresses which the council has supplied are business addresses.
Now, as I've said a few times now, I'll prepare a note of the points that we've discussed today's meeting, including the proposed procedures and timetable. I'll send that out to all that have indicated that they wish to be involved in the inquiry, hopefully by the end of the week. The note, which in effect is a procedure notice, will be an important reference for all parties, as it will record all the main procedural steps required to be taken. So for the avoidance of doubt, I don't intend to issue a separate procedure notice. The note of the meeting will also be published on the DPA website. Now, once you've received the notes, parties will be given 14 days to confirm whether they wish to take part in the inquiry. And it's important to respond within that specified time to guarantee you're kind of involved in the proceedings. And in due course, the proceedings, the inquiry itself will be advertised in. So that's all I was going to be saying today. Perhaps all that remains is perhaps just to go around those that have been attending the meeting today, just to check if there's any other matter that you wish to raise before we close the meeting. So perhaps I'll start with you, Mr. Innes.
No, sir. I think we've comprehensively covered what's coming up, and very grateful for the work that's been put in for the preparation of this pre-examination meeting. Having the topics and the timetables and everything has afforded a really good opportunity for both the applicant to consider matters, but also to liaise with the council and further progress matters. So thank you very much for that. Thank you, sir.
Mr. Brown for the council.
Thank you, sir. Yes, the work in advance has been very helpful in focusing the discussion today. So thank you, sir. There's only one point which occurs to me, and that is to check whether you will be issuing a date for our second pre-inquiry meeting, sir.
Right. Yes. Sorry, you did say helpfully to extend to the end of the month.
Yes, sir. The statement of agreed matters if the period for that could be extended to the end of July, and
yes,
what I'm wondering, sir, is whether it would be your intention to then try to have another pre-inquiry meeting either towards the end of August when the school holiday period is finished, or perhaps early September, at which point the dates, the timetable will already be upon us.
I'm happy to extend the time for comments on agreed matters on landscape and visual to the end of July. I think
Thank you.
Friday the 30th, I think is, yes, Friday the 30th.
Thank you, sir.
And I fully take Mr. Innes's point about the date of the second pre-inquiry. I think if we are to make a provisional booking for accommodation, then that takes the stress out of that particular date. So I mean, if parties prefer it to be the first part of September, I'm happy to do that. I see in this timetable we were going to be submitting statements on the 6th of September. To do it before that, or we could that date. Let's see. Is there a preference? Monday the 6th is September. Brown, are you saying you have a preference for early September?
Oh, sorry, sir. No, I don't have any particular preference, sir, but it does occur to me that if the pre-inquiry meeting was to be maybe a week or two after the inquiry statements were in, that may help to establish the issues which are actually going to be covered during the inquiry.
Mr. Innes?
Well, I think the key point about this one is really, are we in a state to proceed with an in-person or not in-person, and where are we with inquiry preparations? And I would have thought that given the way in which you've set out the timetable, it's very clear what we all have to do within the timescales. So I would have thought that it will be a relatively short meeting, probably shorter than this meeting, but it's really an opportunity to formally say, actually, things are better or worse. And I think the later we put it, the more likely it is to be an accurate depiction of where we sit within the realms of likelihood. So I don't think it really matters. I think later that we do it, the better in some respects. But equally, we all need to book accommodation and other things, which is another matter. So I think there has to be some advance notice. So I think probably slightly later in September would give a clear indication. Although, as most people say, probably to the schools fully back, we won't know what's happening. But I would have thought mid to late September would afford an opportunity to be realistic about the prospects of the in-person inquiry, and as an appropriate timescale in which to say yes or no to that, to attempt it anyway. Because as I say, at any point we may have to resort to the virtual if things changed, but that would seem to be sensible.
Okay. Thoughts on that, Mr. Clapham? This is essentially, as Mr. Innes has just outlined, this would be just to see where we are, certainly with COVID, but also we can press the button on an in-person inquiry.
Yeah, I'm too new to this, so I'll take your advice, really.
Okay. Comments, Mr. Cole or Mr. Kilford?
No, the same. I'm new to this as well, so I'll take your lead. But again, I would like to just stress that the need for having the ability to join virtually as well, because even if the situation has changed, some people may be uncomfortable with travel, some people may not be able to travel, and some people may be
That's a good point.
Traveling through work.
Mr. Kilford?
Yeah, no, I'm fine. I've no further comment.
Okay, super. Do you have any other comment, Mr. Brown? Was it just it?
No, sir, other than to pick up the point which Mr. Innes made, that mid to late September is probably a realistic time frame to know whether we shall be able to have an in-person inquiry about 6 weeks after that date.
Super, thank you. Mr. Clapham, is there any other business?
No other comments from me. Thank you.
Mr. Cole?
Comments from me, thank you.
Finally, Mr. Kilford, is there any other matters that you wish to raise? Sorry, I didn't catch that.
Incoming call at the same time. No further comment from me. Thank you.
Okay, super. Thank you very much. Well, I think that's everything. Well, I just thank everybody for their attendance today. It's certainly been a very useful meeting from my point of view as well. And as I say, I'll try and get a note of the meeting circulated to all parties by the end of this week. So I think all that's left for me to do is perhaps formally close the meeting and say again, thank you for your.
Thank you.
Thank you.